Astonishing. You recast government power, not necessarily even constitutional government power, call it a public right. Somehow that defeats one's merely private constitutional rights. Third, we have to talk about judicial violations of procedural rights, because it's not just, of course, in the administrative agencies. The loss of procedural rights in administrative tribunals gets defended by the courts. So the deprivation of procedural rights persists in the courts. The result is a double violation of rights, first by the agencies, then by the courts themselves. And what this really means is, before the courts really worry about administrative agencies and their constitutional problems, the courts need to look at themselves. They're joining the constitutional violations. To take the clearest example, in appeals to circuit courts, the judges regularly defer to agencies. As we all know, they defer to agencies on the law under Chevron, Auer, or Meet Skidmore respect. They defer to agencies on the facts and relying on the administrative record. They thereby abandon their office or duty of independent judgment. The Supreme Court, obviously, has noted this. That's not the end of the argument, of course. There's an even more serious problem. Where the government is a party to a case, the various deference doctrines require the judges to engage in systematic judicial bias in favor of the legal and factual positions of one of the parties, of course, the most powerful party, which is clearly a violation of the due process of law. Put bluntly, Chevron deference is Chevron bias. Our deference is our bias, so forth. All such deference grossly violates the most basic due process right to be judged without any judicial pre-commitment to the other party. In defense of administrative process, the courts have systematically corrupted their own process. They've redoubled the constitutional dangers. Fourth, we've seen a transformation of procedural guarantees into mere options for government power. What do I mean by this? As a result of administrative adjudication, the government now enjoys ambidextrous enforcement. Whereas the government once could engage in binding adjudication against Americans only through the courts and their judges, it now can choose administrative adjudication. Sometimes Congress alone makes this choice. Sometimes Congress authorizes an agency, such as the SEC, to make the selection. Administrative proceedings thereby change the very nature of procedural rights. It's actually a mistake to think of them as rights anymore. Such rights traditionally were assurances against government. They're now but one of the choices government has in its exercise of power.